Welcome to Assignment 2. Welcome to Assignment 2 Arbitration Hearing Group Project by Ali, myself, Shibjo, Brianna, and Amal. Ladies and gentlemen, esteemed arbitrator, and fellow participants, we, representing the management of the Upper Grand District School Board, welcome you to this mock arbitration hearing. Today, we are gathered here to present our perspective on the grievance filed by the union on behalf of the caretaker, Frank Kelly. At the heart of the matter lies a 10-day suspension imposed on Mr. Kelly for alleged continuing inappropriate behavior connected to the incident that occurred on September 17, 2003 at John F. Ross CVI in Guelph. The incident involved a brief verbal interaction between Mr. Kelly and his shift supervisor, Bridget von Niederhausen, concerning the use of the cleaning liquid in the auto scrubber machine. Before delving into the specifics of the incident, we will focus on our efforts on presenting the merits of our case, demonstrating the necessity of upholding the disciplinary action against Mr. Kelly. To provide context, it is essential to understand Mr. Kelly's disciplinary history. He has previously received 2 suspensions for his incidents occurring in the past 2 years. The first suspension, a 2-day absence without pay, was imposed on December 16, 2002. Which was following a heated exchange with his head caretaker and shift supervisor. The board considered his behavior during this incident as extremely abusive and involving verbal assault causing disruption among teachers and students. The second suspension, a 5-day absence without pay, was imposed on January 9, 2003 for claiming unworked overtime, and he was also required to reimburse first the board for the serious nature of his behavior and his recent suspension. It is crucial to note that these past disciplinary actions went ungrieved and remained part of Mr. Kelly's prior discipline record. While we acknowledge the significance of rehabilitation and the opportunity of personal growth, these prior incidents exemplify a pattern of inappropriate conduct which must be taken into account when evaluating the current suspension. Turning our attention to the incident in question, we acknowledge both parties' factual descriptions as being quite similar. Ms. von Niederhausen and Mr. Kelly's shift supervisor approached him on the night of September 17, 2003 to reinforce instructions regarding the proper use of an auto scrubber machine. She reminded him, as well as other caretakers, not to use vinegar in the machine, as it was a corrosive to both machine and the floor wax finish. Despite previous reminders and discussions on the matter, Ms. von Niederhausen encountered resistance from Mr. Kelly, who responded with the remark that she perceived as rude and disrespectful, undermining her authority as a supervisor. As a representative of the management, we firmly believe that the griever's comment cannot be taken lightly. It is vital to maintain respectful and cooperative working environment, especially in an educational institution where caretakers serve as role models for students. Disrespectful behavior has no place in our school and are contrary to the guidelines set out on the employee handbook. In this hearing, we will demonstrate that disciplinary action taken against Mr. Kelly is warranted and considering his prior disciplinary record, that the seriousness of the current incident and the need to uphold a standard of professionalism and mutual respect within our school community. We rely on the evidence and facts presented to establish the meaning of our decision and emphasize the importance of maintaining a positive work atmosphere for all staff members. With this introduction and background, we look forward to presenting a compelling case that justifies the management's position in upholding the 10-day suspension. Thank you for your attention, and we will now proceed to present our arguments and evidence before the esteemed arbitrator.
As management, it is our duty to ensure that the safety and well-being of our employees and others around them are being met at all times. We cannot justify that all that has happened, so we need to come to a conclusion that Frank Kelly be suspended from the position for 3 days and will be paid for any lost wages. The situation was handled unprofessionally. Ms. von Niederhausen should have pulled Mr. Kelly away from the others and spoke with him in a professional manner and should have asked, "We notice that the vinegar is being used in the machines. As stated before, it can really damage the machines. Do you know anything about this?" Instead, she embarrassed Mr. Kelly in front of others, basically accusing him of being the one doing so. This should have been a verbal warning, but because of the acts of abusive language used and humorous jokes said, now it has to be a written warning. Because this is not Mr. Kelly's first offense. We need to follow through on more training for both employees and superiors in charge. Mr. Kelly was aware of any serious occurrences again, could this time get him terminated with already having 2 previous suspensions. If it were up to us, we'd like to have Mr. Kelly terminated, but it is not being a serious matter. There's not much we can do. Supporting evidence. Miss von Neerdehusen had went to talk to Mr. Kelly and another employee and said she would really appreciate it if they could not put vinegar on the floor in the floor machine, especially the new one, and got a response from Mr. Kelly saying, "What do you want me to use? Piss?" This is the wrong way to question an employee, and this is the wrong way to respond to a superior supervisor. On December 16, 2002, Mr. Kelly had been suspended for 2 days without pay for having a heated exchange in the technical studies wing in a secondary school with his head caretaker and shift supervisor. This was seen as an abusive fashion. On January 9, 2003, Mr. Kelly was suspended for 5 days without pay for claiming overtime that was not worked. Mr. Kelly was to reimburse the board of $265.13. At the end of the shift, the employees have a 5-minute wash-up break before they leave. Mr. Kelly was finished washing up. Instead of sitting in the crammed lunchroom, he stood by the exit door, not leaving the premises. Miss von Neerdehusen approached Mr. Kelly, explaining that he cannot yet leave and he should be sitting in the lunchroom with everybody else.
My name is Anna. Today, I'm representing the arguments. In our opinion, as management, the griever's behavior is respectful, inappropriate, and insubordinate. First, how it is inappropriate. Inappropriate remarks and disrespect. We find the griever's remarks against Ms. Van disrespectful and inappropriate in accordance with the employee handbook. Number 2, undermining authority. Since Ms. Van comments was made on front of another caretaker, it determined her authority as a supervisor. Third, past disciplinary record. When determining whether an escalated and disciplinary action is warranted, in this case, a 10-day suspicion, the griever's past disciplinary record is taken into account. 4, it is important to maintain a respectful and professional workplace, especially in a school environment where employees serve as role models. There is concern that the griever's action will negatively affect the work environment and the morale of the team. 5, management rejects the shop talk. Defense. Management acknowledges that casual and explicit language known as shop talk occurs at work, but claim that this does not justify the griever's disrespectful remarks. According to us, the griever's behavior goes beyond casual banter and constitutes insubordination. 6, Ms. Van discomfort. Management emphasized that Ms. Van reported the incident, indicating her discomfort and concern, which attests to its severity. Us, as management, believe that the griever's actions are contrary to its goal of maintaining a respectful and professional work environment. The griever's past record suggested that the comment was not only disrespectful and insubordinate, but also exceeded the boundaries of acceptable shop talk. According to us, disciplinary action in this case, a 10-day suspicion, is necessary. So, our rebuttal. From the management's perspective, the union argument can be rebutted as follows. First, severe disrespect and insubordination. According to management, the griever's comment was not only appropriate, but also disrespectful and insubordinate, challenging the supervisor authority. Second, context does not excuse behavior. Although the union asserted that shop talk has a context, management asserted that such as context cannot excuse or justify disrespectful or insubordinate behavior. Third, a griever's past disciplinary record should be considered in conjunction with the nature of the current incident, according to the union. The management emphasized, however, that the griever has already been warned and further issues may result in severe disciplinary measure. Fourth, professional conduct. The management stresses the importance of upholding professional conduct and argued that the griever's action negatively impact the school's work environment and morale. Fifth, impact on supervisor. Management highlights Ms. Van Distel's and concern over the griever's statement, arguing that it underscored the severity of the incident. Last, the importance of upholding disciplinary actions. Management believes that the 10-day suspension is necessary in light of the griever's period record and the severity of the misconduct. So, leniency might be interpreted as endorsing such behavior, which can further degrade the work environment.
So after reviewing all these evidence and reading the case over, we've came to decision that we would want the employee to be suspended for at least 10 days. And this suspension would be without pay, since this is the act of the employee, since he's in the wrong, so it would be without pay. Also, employees should be put on probation when he does come back to work, and when they decide he's able to come back to work, they should also monitor the work environment to see when he comes back how the work environment changes and when he is gone. Provide verbal and oral warnings, and you want to make sure that you track these incidents further to make sure if any incidents are if these incidents do occur again, you want to make sure that they're filed in case the employee is subjected to dismissal if these cases do continue and the employee still isn't demonstrating a good work environment. Also, the union representative was supporting the employee, while when the union representative was supporting the employee, the representative, the union rep himself, was facing suspension for misbehaving and swearing at people at the team. And next, I would like to come to a conclusion. So the evidence has came down to that he does get suspended for the 10 days, and also evidence for misconduct. All the information was given and reviewed. Enough evidence is provided for the suspension. Supporting evidence has been brought forward, and valid arguments were made by management also. There was also a lot of valid arguments that the union wanted to make, but our recommendations and our arguments were way stronger because the employee was in the wrong. Rebuttal has been made by the management. If this continues, it will result in a negative work environment.